In the medieval criminal justice system, the people were represented by two separate yet equally important groups: the courts, who administered justice, and the pigs, who were required it administered upon them. The following proceedings are documented. In my secondary career as a certified auditor for 14th century French municipal budgets, I have reviewed a number of expenditure reports that give me pause. There was the 1356 allocation for additional crossbow maintenance following a minor disagreement with England. There was the 1391 invoice for ceremonial banquet refreshments filed during a famine, but nothing, and I want to be precise here, nothing prepared me for the line item that simply read, Professional Executioner's Fee, 1 pig. This is the story of medieval Europe's most elaborate, most expensive, and most legally rigorous system for prosecuting farm animals. Regrettably, it makes complete sense. France, late medieval period, roughly 1350 to 1500 AD. The continent is, administratively speaking, experiencing some turbulence. The Black Death has recently concluded its unsanctioned tour of the European workforce. The 100 Years' War is proceeding from a scheduling standpoint somewhat over its original projected timeline by about, give or take, 93 years. And then there are the pigs. Pigs in medieval Europe were not the pin-contained, performance-reviewed livestock units of the modern agricultural complex. They roamed freely throughout village streets, operating as unsupervised interns with no behavioral framework and no reporting structure. And occasionally, regrettably, they committed crimes. The medieval legal system, drawing on Roman law and canon law with characteristic thoroughness, arrived at a solution that was, from a philosophical standpoint, internally consistent. If a pig caused harm, the pig would stand trial. Today, we are going to review 3 such cases. They escalate. Before we proceed to the case files, a brief institutional orientation. Animal trials in medieval Europe were not rare. Historians have documented well over 200 such proceedings between the 9th and 18th centuries. The defendants included pigs, rats, weevils, a colony of moles, and in one particularly ambitious prosecution, an entire field of caterpillars that had consumed a local vineyard. The caterpillars won. The theological basis for all of this was straightforward. God had granted mankind dominion over animals. If an animal violated God's natural order, it fell under human and therefore divine jurisdiction. The courts appointed defense attorneys. They paid for the animal's room and board during the pretrial. They summoned witnesses. They deliberated with genuine seriousness. The animals, for their part, contributed nothing to their own defense, which, and I say this as someone who has observed a number of legal proceedings, is not always a disadvantage. Case file number 1. Mortagne, France, 1394. I doubt I said that right. I'll put the spelling up here. The defendant, 1 pig, breed unspecified, hereafter referred to as the accused. The facts are not in dispute. The accused entered the Church of Saint Jean during what appeared to be an unattended moment in the liturgical calendar. Upon locating the sacristy, it consumed a quantity of consecrated communion wafers, the host, which under Catholic doctrine represented the literal body of Jesus Christ. I want to be precise about what this meant legally. The pig had not simply stolen food. It had, according to the prevailing theological framework, committed an act of desecration against a divine entity. This was not a property crime. This was sacrilege. The distinction mattered enormously and not in the pig's favor. The pig was arrested. Formal complaint was filed. The ecclesiastical court convened. And here is where the prosecution encountered a minor procedural complication. The pig had no soul. Canon law generally reserved punishment for beings capable of sin, and sin required the capacity for moral reasoning. The pig, by all observable measures, lacked this capacity. It had entered a church, it had eaten the wafers that were the Lord, it had absolutely no theological opinion on the matter. The court addressed this efficiently. Since the host was divine, its desecration constituted harm to the spiritual community regardless of the perpetrator's intent. The pig was found guilty. The pig was sentenced to hang. The execution was carried out. The town filed the invoice. At this juncture, it's worth pausing to consider what was actually happening here. Not theologically, but psychologically. Behavioral economists refer to a concept called moral externalization, the human tendency to project blame onto external agents in order to preserve one's sense of social order. For example, when a child dies, when a crop fails, when a priest's sacred wafers are consumed by a farm animal, the community requires an explanation that is both legible and punishable. The pig provided that. The pig could be arrested. The pig could be tried. The pig could be hanged in the town square, after which the community could observe the execution and return home with the quiet satisfaction of a civilization functioning as intended. The fact that the pig had no awareness of the process was, from a sociological standpoint, completely besides the point. What the trial was really about was not the pig. It was about the community's need to demonstrate its moral framework was enforceable, even against a pig, especially against a pig. This is, if you reflect on it, not entirely dissimilar from several modern institutional communication strategies I could reference, but I won't because this channel maintains a strict editorial policy of not providing commentary on living bureaucracies. Case File 2, Falaise, France, 1386. 8 years prior to the Mortagne Incident, the previous pig, exponentially more committed in the execution, pun noted, not withdrawn. The accused, one sow, the charge, murder of a child. The facts were not in dispute. The sow had attacked and fatally injured an infant. From an evidentiary standpoint, this was a closed file. The difficulty was philosophical, though. The presiding judge, a man whose name history has not preserved but whose legacy is permanent, determined that justice required not merely the execution of the pig, but its symbolic processing through the human justice system in its entirety. His reasoning: if the sow had committed a human crime, it would be treated as a human offender. Procedurally speaking, from start to finish, what followed was a series of decisions that I will describe with full professional seriousness as thorough. The sow was brought from its holding cell, the cell for which the town had been paying daily lodging and feeding costs since the date of the sow's arrest and transport. The town of Falaise commissioned human clothing for the pig, specifically a jacket, breeches, and a pair of white gloves. The trailer was paid, the fee was recorded. The sow, now fully dressed in what was, by all documentation, a complete formal outfit, was escorted to the town square for public execution. The crowd was large, and in what I can only describe as an aspirationally ambitious pedagogical choice, the local government had also required a number of the town's other pigs to be present as witnesses. The working theory being that observing the execution would serve as a deterrent for future criminal behavior in the local swine population. There is no documented evidence that this produced measurable results, but one can hope, right? Now, I'm going to briefly interrupt this proceeding to note that if you're finding this content of value or at least entertaining, or if you are simply relieved that you were not a taxpayer in the 14th century, the appropriate response is to engage with the subscribe button and the like function below. Okay, let's resume. The total cost for this proceeding, pretrial detention, legal administration, tailoring, a professional execution service, represented what historians estimate was a significant fraction of a small village's annual operating budget. The town of Falaise, or however you say it, had, in summary, dressed a pig in a suit, charged its citizens for the privilege of executing the pig in front of a mandatory audience that included other pigs. The pig did not at any point express gratitude. Case File 3. Savigny sur Grosny. It's in France again. France is crazy. I'm going to put the name here on the screen somewhere. This case introduces a legal complication the previous two did not possess. A family. The accused, one sow, her 6 piglets. The charge, the murder of a 5-year-old child. Children are just getting killed left and right by these sows. I don't know what to tell you. The sow, it was established through witness testimony, had initiated and primarily conducted the attack. The piglets had been present at the scene. They were recovered, covered in blood. The sow was tried first. The verdict required minimal deliberation, as you would imagine, guilty. Sentence, death. The piglets presented a considerably more nuanced procedural challenge. The court appointed a defense attorney, and here I want to pause because the attorney's argument is, from a strictly legal standpoint, more sophisticated than a great deal of legislation I have personally reviewed. The argument was as follows. The piglets were minors. They had no prior criminal record, as piglets generally don't have. They had been raised under the direct supervision of a sow who had, as the court had just formally established, significant behavioral deficits. They were at the scene, and obviously they were covered in the blood of the victim. But there was no direct evidentiary proof that they had participated in the attack, as distinct from merely having observed the attack. This is functionally a combined argument of diminished capacity and absence of actus reus, the legal term for they may have been there, but you cannot prove they did the thing. In most jurisdictions, this argument would be a minimum warrant consideration. In 15th century France, it won. The judge deliberated. The judge agreed. The piglets were acquitted and released. The official record does not indicate whether they were subsequently placed under any form of behavioral monitoring or community supervision, which, given the general state of the 15th century data infrastructure, is perhaps understandable. The sow was executed. The defense attorney was paid. The town filed its invoices, and the case of Savigny, that town, entered historical records as, among other things, the first documented successfully diminished capacity defense in which the defendants were constitutionally unable to communicate with their own legal representative because they were baby pigs. There is a concept in social psychology called system justification theory, which holds that individuals, and by extension entire communities, maintain a strong cognitive motivation to believe that the systems they operate within are fair, legitimate, and functional, even when the observable evidence suggests otherwise. Medieval animal trials are, from this analytical perspective, a case study of remarkable clarity. A child has died. This is intolerable, and it requires resolution. The community possesses a legal system. The legal system must be seen to function. The pig must be tried, right? Because the alternative, formally acknowledging certain harms fall outside the remediation capacity of the existing institutions, is psychologically unsustainable for a community that depends on those institutions for its basic social coherence. The trial is not for the pig. The trial is for the town. And there is what I find, professionally speaking, most instructive. The system worked, not in the sense that it produced justice. The pig was entirely unaware of the proceedings, but in the sense that it produced order. The community observed the process. The community observed consequence. The community continued to function. This is not, I would suggest, an exclusively medieval phenomenon. Every era applies its existing institutional frameworks to situations those frameworks were not originally designed for, because the alternative, building entirely new frameworks, is expensive, slow, politically inconvenient. The frameworks change across history. The instinct to apply them does not. I decline to provide contemporary examples. I trust your judgment. A final note on the economics, because in my secondary career as a consultant for artisanal pencil sharpeners, I have developed a refined sensitivity for unnecessary operational expenditure. Across the documented history of medieval animal trials, the financial pattern is consistent. The municipality bore the full cost. Pre-trial detention meant feeding the animal. A defense attorney meant paying a lawyer at professional rates. The executioner was a skilled tradesperson, not a volunteer. In cases like Falaise, there were also tailoring fees. In some documented cases, there were costs for formal processions, civic assembly, and in at least one instance, a formal meal provided to the attending magistrates. The trial of the Falaise sow is estimated to have cost the town the rough equivalent of a mid-level municipal official's annual salary. For the prosecution of one pig, the taxpayers of the 14th and 15th century France funded a sophisticated, legally rigorous system for trying farm animals in the entirely sincere belief that this represented sound civic governance. I want to be careful to not be dismissive. These were sincere people operating within a sincere framework, doing what they genuinely believed a functioning society was obligated to do. They simply believed it in an extremely expensive way with excellent record keeping. The record keeping is honestly impressive. So, 3 case files, 3 verdicts, 1 pig executed for sacrilege, 1 pig executed in a tailored jacket in front of a mandatory audience of other pigs, and 6 piglets acquitted, released, and returned to general circulation, their legal status formally unblemished despite the circumstances. Total expenditure substantial. By any era's accounting standards, the lesson is not that medieval people were unintelligent. The historical record does not support that conclusion. The lesson is that intelligent people operating within a coherent institutional framework will apply that framework consistently, even when the situation to which it is being applied is, from an outside perspective, a pig in a courtroom. Every era does this. The frameworks change. The instinct does not. The need to process disorder through recognized structures to make the chaotic legible, to make the unpunishable punishable, is not a medieval peculiarity. It is a human constant. And until someone invents a framework specifically designed to tell a community that some problems simply cannot be formally adjudicated, the proceedings will continue. The pig, across all documented cases, never once questioned the legitimacy of the process. This is either a testament to the composure or evidence that self-awareness is not ultimately a prerequisite for full participation in institutional systems. I leave this interpretation to your discretion. If this analysis has been of use to you, or if you have at any point in the last 12-ish minutes experienced something that a more excitable presenter might have classified as entertainment, I would direct you to the subscribe button and the like function below this video. There are additional case files, there are additional invoices. There is regrettably a full documented trial on a rooster accused of laying an egg, which under prevailing theological interpretation was considered a sign of demonic activity and for which the rooster was subsequently and formally executed. We will get there. Let me know if you would like me to discuss that in greater detail. In the meantime, subscribe and stay, as always, clinically detached.